Your Honor.
Why'd you have the gun?
No, for protection, because it's a lot that go on out here. The gun was not intended
Is that your mother?
No, that's my grandma.
Look at your grandma right now. She heard what she heard. You should have seen her face when the prosecutor said those facts that you had this gun.
We are here in the case of State of Ohio versus Willie Crenshaw, the third, case number 25 CR 311. Defendant is present, represented by defense counsel. We're here for a change of plea hearing. State's offer in this case is count 2, carrying a concealed weapon, felony of the 4th degree. The state has not committed to any sentencing recommendation at this time as a part of this offer. It's my understanding the defendant wishes to accept the offer.
Thank you. Mr. Hinton, is all that accurate?
That is, Your Honor.
And Mr. Crenshaw, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes, Your Honor.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty to count 2 and plead guilty to that charge. Counts 1 and 3 would get dismissed. We would defer sentencing, get some reports completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they think is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly, what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. You need to make sure you understand what you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties that you face. So for me to determine those issues, I will ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to talk with your lawyer so you could ask him questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
Okay. All right, let's get started then. How old are you, sir?
18.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yeah.
Sorry?
Yes, Your Honor.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No, Your Honor.
What about in the last 48 hours?
No, Your Honor.
Not even prescribed medication? Nothing?
No.
Okay. Yeah, you should have received a copy of this indictment probably around middle to end of April. Do you remember getting that? That's the document that says what the charges are?
Yeah, Your Honor.
And did you have a chance at some point to look that over?
Yeah, Your Honor.
Now, in that indictment, you are charged with 3 counts. You're only pleading to one of them. And that's count 2. And in count 2, what's alleged here is on or about March 7th, 2025, as a part of a course of criminal conduct in Cuyahoga County and Lake County, Ohio, that you didn't knowingly carry or have concealed on your person, ready at hand, a handgun other than a dangerous ordinance, that being a Glock 20 pistol. It's further alleged the weapon involved was a firearm that was loaded or for which you had ammunition ready at hand. That conduct constitutes the offense of carrying concealed weapons. It is a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 2 here?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Now, the charge also carries what we'll call a forfeiture specification, which alleges during the commission of the offense you had in your possession this Glock 20 pistol, which was used as an instrumentality, which means it's property that was used to commit or facilitate the commission of an offense. And the whole point of this is that you forfeit any right you have, ownership right you have to that firearm. You understand that? It doesn't increase any potential penalty you face or anything like that, but you just forfeit any interest or ownership interest you have. You understand that?
Yes, Your
Any
Honor.
questions about that?
No, Your Honor.
Now, there are 2 other counts of the indictment. Those are being dismissed pursuant to the agreement. Is that your understanding?
Yes, Your Honor.
Do you have any questions about any of those 2 charges?
No, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have a trial. Now, a trial could be to me as a judge, or I listen to all the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial will be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would then consider and weigh all that evidence, and then those jurors will make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision, which means all 12 jurors would have to agree together, one way or the other, as to each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial?
Yes, Your Honor.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation, she bears the burden to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of this charge, and that presumption of innocence stays with you throughout all the proceedings until the state, if at all, is ever able to overcome that presumption and prove you guilty at a trial. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since it is a criminal case, the burden is what we refer to as proof beyond a reasonable doubt. And that is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or part of this charge beyond any reasonable doubt before you could ever be found guilty of this charge. You understand that?
Yes, Your Honor.
Do you understand that by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to do that, or at least to try to do that if we had a trial, the prosecutor would bring witnesses to come into court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. He could ask him anything he wanted to, within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty or giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You can call your own witnesses to come into court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right, if we went to trial, you could call your own witnesses to come to court to testify for you if you wanted, though you're not obligated to do that. That's a decision that you'd have to make for yourself. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court to testify for you and answer your lawyer's questions if there was someone that wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
Do you realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you alone would have to make. Do you understand that?
Yes, Your Honor.
And since that's ultimately your choice, what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you did not want to. I can't make you testify. But more importantly, the prosecutor is not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
Further understand that if we did go to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty today, you're giving up or waiving any right you have to appeal any guilty finding that I will make if I accept your guilty plea, as well as any other issues that you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, well, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
You understand a guilty plea is a complete admission of guilt. That means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as sentencing goes, you're pleading guilty to a felony of the fourth degree. This is punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
You're currently on probation or parole to any of the courts or agencies?
No, Your Honor.
Give me 1 second, please. All right, sorry about that. Do you have any other charges pending against you anywhere right now?
No, Your Honor.
Now, if you are sent to prison, upon your release from prison, you could be placed on what we call post-release control. It's sometimes called parole. That's a period of supervision you would be on after you served the prison sentence, and it could be for up to 2 years. You understand that?
Yes, Your Honor.
And if you are on post-release control and you violate any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined up to $5,000. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any of that were applicable. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained the possible prison sentence you face. I did use the word possible because prison is not mandatory with these charges. You are eligible for probation, or what we refer to as community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information that gets presented to the court. Then I'll make the decision that ultimately I think is the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you are put on community control, it could be for up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions can be an order that you serve a term in our Lake County Jail of up to 6 months as a condition of your probation. Do you understand that?
Yes, Your Honor.
Further, if you are put on probation and you ever violate any of the conditions of your supervision, we will have a hearing here in court to see if you're what's called a probation violator. If it's determined that you are, I could extend your probation up to 5 years if it wasn't originally 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. And if I did that, again, it could be 6 to 18 months in prison, and that could be consecutive to any other prison sentence that you may be serving for something else or that you're being sentenced to at that time for something else. Do you understand that?
Yes, Your Honor.
Lastly, when we do proceed to sentencing, you're going to have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. He could recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes, Your Honor.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty?
No, Your Honor.
You understand all the possible consequences?
Yeah.
Do
Yes,
do
Your Honor.
you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer? Have him go over the reports with you, discuss whatever issues there are, answer your questions?
Yes, Your Honor.
Are you satisfied with his advice and counsel
Yes, Your Honor.
of your lawyer?
Yes, Your Honor.
Has he or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty?
No, Your Honor.
Are you entering this guilty plea freely and voluntarily?
Yes, Your Honor.
All right. Do you have any questions then for me at this time regarding anything we've just talked about? The rights you're giving up, the penalties you face, what you're pleading guilty to?
No, Your Honor.
Do you need any more time to talk to your lawyer before we go forward with your plea?
No, Your Honor.
All right, then what's going to happen now is that the prosecutor here is going to explain for me what the facts would show regarding this count 2. I want you to listen to her and what she says because I'll have some questions for you about that, all right?
Yes, Your Honor.
All right, Mrs. DeGrazia?
The evidence would show that on March 7th, 2025, in Willoughby Hills, Lake County, Ohio, Willoughby Hills officers started to follow a vehicle for traffic violations and was also waiting for confirmation as to warrant status for a registered owner of the vehicle. Proceeded to follow the vehicle into Cuyahoga County and then initiated a traffic stop by turning on the lights and sirens to the police cruiser. The driver of the vehicle did not comply with those orders and continued to drive and exit onto Wilson Mills Road. The defendant was not the driver, he was in the back seat. The driver, however, made multiple traffic violations and ultimately disabled his vehicle in the Golden Gate Plaza off of Mayfield Road. The defendant, along with the driver, then ran to the back of the plaza and jumped the fence and was eventually apprehended with the assistance of Mayfield Heights Police and Highland Heights Police. Officers searched the vehicle and in the back seat where the defendant was seated, a Glock 20 was found between clothes and partially in a book bag. There was 1 round in the chamber and 12 rounds in the magazine. The defendant was 18 years old at the time. The defendant admitted to handling the gun when interviewed back at the Willoughby Hills Police Station.
Mr. Crenshaw, were you able to hear what the prosecutor had to say regarding what he believes the facts would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts? Are they true? Did you do what he said?
Yes, it was true, Your Honor.
Why'd you have the gun?
For protection, because it's a lot that go on out here. The gun was not intended
Is that your mother?
No, that's my grandma.
Well, look at your grandma right now. Should have heard what you should have seen her face when the prosecutor said those facts that you had this gun. So those facts are true?
Yes, Your Honor.
Very well. Regarding count 2, charging with carrying concealed weapon, a felony of the 4th degree, what is your plea?
Guilty.
Hope you remember this. I have in my possession right now a document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document, that you sign it here in court. My understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes, Your Honor.
Mr. Hinton, is that accurate?
Yes, Your Honor.
You reviewed this and read it over with your client?
Yes, Your Honor. He read it, and I went over any questions that he had regarding it.
Did he indicate an understanding of it to you?
He did, and he had it ahead of time as well. I sent him an electronic copy a few days ago.
Is that correct, Mr. Crenshaw?
Yes, Your Honor.
You understand what this document says?
Yes, Your Honor.
Any questions for me about what it says?
No, Your Honor.
Did you sign the document?
Yes, Your Honor.
Mr. Hinton, you witnessed that?
Yes.
Yes.
Mr. Gretzky, you as well?
Yes, Your Honor.
Very well. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect. Defendant was here in open court with his lawyer. Advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea, find the defendant guilty of count 2, carrying concealed weapon, felony of the 4th degree in violation of 2923.12A2, along with the forfeiture specification. The remaining counts will get dismissed at sentencing. I'm going to, the first sentencing, order a pre-sentence report and investigation. Any other reports you're recommending or requesting?
No, Your Honor.
You have any issues with any drugs or marijuana?
No, Your Honor.
You're not going to test positive for marijuana?
No, Your Honor.
All right. So pre-sentence report and investigation. A continued bond of $20,000 cash surety with the condition that the defendant not drive. So what all this means, Mr. Crenshaw, as far as bond goes, I've continued your bond. There's nothing more you need to do at this point regarding that except to continue complying with the conditions of your bond. Again, one of those is that you don't use any drugs, which includes marijuana. If you do, you're going to have to submit urine screens. If they come back positive, your bond would be revoked and a warrant would be issued for your arrest. You understand that?
Yes, Your Honor.
Purpose of this report I've ordered is so I can learn more about you before sentencing, and the way the probation department gets the information they need is they'll conduct an interview with you. It's important that you show up when you're supposed to, on time, and that you're open and honest with them, because they're going to check and verify everything you tell them. If they learn you're misleading them in any way, they're going to let me know, and I'll consider that at sentencing. You understand that?
Yes, Your Honor.
You also need to make sure that you do show up when you're supposed to, because if you don't show up for that interview, and that means they can't conduct the interview with you. If they can't do an interview, they can't do a report. And without a report, the law doesn't even allow me to consider probation as an option. And I won't continue the sentencing to another day to get the interview done because it wasn't completed initially because you didn't show up when you were supposed to. Do you understand that?
Yes, Your Honor.
All right, so you're going to leave here right now. You're going to go to the probation department. Your lawyer will show you or tell you where that is. You're going to meet with them, fill out some initial paperwork, and get your date to come back for that interview. So make sure you do that right when you leave here, okay?
Yes, Your Honor.
All right, Mr. Hinton, anything else?
Nothing further, Your Honor.
Mr. Gretzky?
No, Your Honor.